This story contains complex conflicts and sensitive situations. Viewer discretion is advised.
The glass did not fall straight down. It came toward my face. We were halfway through dinner in a private room overlooking Elliott Bay when my sister's hand crossed in front of me. I had just lifted my wine for a toast. The stem struck the edge of the table with a sharp crack, and the bowl exploded sideways. I felt something hot and immediate along my right temple before I understood what had happened. Someone said it was an accident. Someone else reached for napkins. My sister Taryn was already apologizing, saying the glass had slipped in her hand. Blood ran past the corner of my eye and onto the collar of the dress I had chosen that morning because it felt calm and adult. I remember noticing the sound in the room more than the pain. Forks set down, chairs scraping. My fiancé Daniel standing so quickly, his chair tipped backward. The restaurant manager came in within seconds. They had heard the break. I was guided into a hallway near the kitchen where the light was harsh and stainless steel reflected everything. A server pressed clean bar towels against my face. When I pulled my hand away to see how bad it was, there were small shards of glass embedded along the cut. Taryn stood a few feet away, pale, repeating that she hadn't meant to reach so far, that the stem was wet, that she had only been trying to steady it before the toast. It was a Thursday night in early May. The dinner had been planned for weeks. Daniel had booked the private room after we finalized the date for our wedding. My mother had flown in from Denver that morning. The duplex in Tacoma that my sister and I co-managed through our father's trust was scheduled to close in 3 weeks. We had all known that. We had also known that I hadn't yet signed the final sale documents. No one mentioned that in the hallway. An ambulance wasn't necessary, the manager said, but they insisted on calling for medical assistance. I declined the ambulance and agreed to let Daniel drive me to the ER. Before we left, I saw one of the staff members carefully sweeping up the broken glass and placing it in a bus tub. Another employee spoke quietly with a supervisor near a wall-mounted camera. The ride to the hospital was less than 15 minutes. I held gauze against my temple and tried to keep my eyes open. Daniel kept asking if I felt dizzy. I told him I didn't know yet. At the emergency room check-in desk, I gave my name and insurance information. The nurse asked how the injury happened. I said a wine glass shattered during dinner. She typed that into the intake form without looking up. While we waited, I watched other families in the chairs across from us. A father holding a child with a wrapped wrist. An older couple sitting shoulder to shoulder in silence. It felt strange to be there in an engagement dress, makeup half gone, gauze taped to my face. When they called my name, Daniel started to follow. A nurse told him he could wait outside the treatment area until I was settled. In the exam room under fluorescent light, the doctor irrigated the wound and removed visible fragments with forceps. He asked me to stay still. He asked again how it happened. I repeated that the glass had slipped during a toast. He did not respond immediately. He adjusted the overhead light and leaned closer, examining the angle of the cut. The question he asked next was quiet and precise. Was the glass falling down, or did it come toward you? I did not answer right away. Outside the room, I could hear a cart rolling past and a monitor beeping steadily somewhere down the hall. My sister had said it slipped. Everyone at the table had accepted that explanation within seconds. The doctor waited for me to clarify. I realized then that I was not entirely certain which version of the night was true. He ordered imaging to rule out deeper injury. As I lay back on the narrow hospital bed, I understood one thing clearly: if the glass had not slipped, then the dinner was not an accident. And if the dinner was not an accident, then I had been sitting in a room full of people who did not see what was happening. I closed my eyes as they wheeled me toward radiology, and for the first time that night, I felt something other than shock. I felt uncertainty about my own safety. It was still Thursday night when they finished the imaging. The CT ruled out fractures around my eye and skull. The cut required 8 stitches. After irrigation, the physician documented the depth and direction of the laceration in the electronic chart. I watched him dictate into a handheld recorder clipped to his badge. He described the wound as lateral with embedded fragments, consistent with forward motion, rather than a vertical drop. He asked again for clarification about the mechanism of injury. I repeated what I had told intake: a wine glass shattered during a toast. He noted in the record that the reported mechanism and the physical presentation did not fully align. He did not accuse anyone. He did not speculate. He entered mechanism uncertain and added a line that read, "Consider assault versus accidental laceration." When the nurse cleaned the dried blood along my hairline, she paused over two faint pale marks slightly above the fresh sutures. They were thin, nearly invisible, unless you knew where to look. I had never given them much thought. The doctor asked when those earlier injuries occurred. I told him I did not remember clearly, probably years ago. He ordered a closer look at the area through imaging already completed and confirmed there was no new structural damage. The scars were superficial, healed long ago. He added them to the physical findings. Before discharge, he handed me printed instructions for wound care and a summary sheet. Under the section labeled Cause of Injury, the description remained neutral but precise. He explained that if I believed the injury was intentional, I had the option to file a police report. The hospital would not do so automatically without my statement, unless mandatory reporting criteria were met. He told me to return immediately if I experienced vision changes, dizziness, or confusion. Daniel was waiting in the lobby with my coat folded over his arm. It was nearly midnight. The waiting area had thinned out. As we walked to the parking garage, I felt the weight of the discharge papers more than the stitches. In the car, Daniel asked if I thought it was deliberate. I told him I did not know. That was still technically true. Back at my apartment, I placed the hospital packet on the kitchen counter next to the engagement invitation proofs I had been reviewing earlier that week. The contrast unsettled me. One stack outlined seating charts and catering deposits. The other documented a wound and a question mark. Before going to bed, I logged into my patient portal to confirm the visit summary had uploaded. The notes were already visible. The wording was clinical restrained but unmistakable in its implication that the physical evidence did not perfectly match the explanation. I closed the laptop and stood in the quiet of my living room. Outside traffic along Alaskan Way had slowed to a distant hum. What had happened at dinner now existed beyond memory. It was entered into a medical system with timestamps, diagnostic codes, and an attached imaging file. It was no longer only a family story told around a table. It was a record. And records tend to outlast explanations. By Friday morning, the swelling had set in. I worked from home that day, camera off for internal meetings at the firm. The stitches pulled when I turned my head too quickly. Around 10, I opened the shared digital folder that held the Ellison family trust documents. 3 years earlier, after our father's death, the trust had been structured to hold 3 rental properties in Tacoma. Taryn and I were named co-trustees. Major decisions required both of our signatures. The language had felt symbolic at the time, something about shared responsibility and balance. Now it read differently. The duplex on South Yakima Avenue was under contract. Closing was scheduled for the end of the month. I had reviewed the preliminary settlement statement earlier in the week, but had not yet signed the final authorization for release of funds. The buyer's earnest money was already in escrow. If the sale collapsed, we would lose time and possibly incur penalties. At 11, I emailed Martin Feld, the estate attorney who had drafted the trust. I asked for clarification on trustee removal provisions and whether one co-trustee could initiate a process claiming the other was medically unfit. He responded within the hour and suggested a brief call. Martin's office was in Bellevue, but he handled most communication by phone. He spoke carefully, as he always did. Under the trust terms, removal of a co-trustee for incapacity required documented medical evidence and, if contested, court review in King County Superior Court. It was not a casual process. Then he added something I had not asked. Taryn had contacted his office 2 weeks earlier. She had inquired generally about what documentation would be needed if a trustee were unable to perform duties due to medical issues. She had not filed anything. She had only asked questions. Martin had documented the inquiry in his internal notes, as he did with all client communications. I thanked him and ended the call. The timing settled heavily. 2 weeks earlier, the duplex buyer had requested confirmation of closing dates. 2 weeks earlier, Taryn had also pressed me to move faster to stop over-analyzing the numbers and sign. I logged into the trust's online banking portal. As co-trustees, we both had view access, but transactions over a certain amount required dual authorization. I reviewed recent activity, routine rent deposits, property tax payments, insurance premiums, nothing unusual. Still, I downloaded the last 6 months of statements and saved them to a separate encrypted folder on my laptop. It was a precaution, not an accusation. Around mid-afternoon, Taryn texted, asking how I was feeling. She wrote that she felt terrible about the dinner and hoped I would not blow it out of proportion. She added that the buyer's agent had called her directly and wanted reassurance the closing would not be delayed. I did not respond immediately. The trust agreement required that all sale-related communications be documented. I forwarded the buyer's prior email threads to myself and flagged the timeline. The earnest money deposit was held by a licensed escrow company in Tacoma. Any delay beyond the contractual window could expose the trust to claims. By early evening, I had a spreadsheet open comparing projected net proceeds from the sale against outstanding maintenance costs on the other 2 properties. The numbers were not dramatic, they were stable, conservative. There was no financial emergency that justified urgency beyond the scheduled closing date. When Daniel came home from work, I showed him the email from Martin summarizing Taryn's inquiry about trustee incapacity. He read it twice. He asked if I thought she was preparing something. I told him I did not know yet. But I understood that questions about medical unfitness were rarely hypothetical in estate planning. That night, I placed the printed trust agreement on my desk, instead of returning it to the filing cabinet. I marked the section on trustee removal with a small adhesive tab. Nothing irreversible had happened, but for the first time since the dinner, I saw a line connecting the injury to something larger than a broken glass. It ran through legal language and signatures. The call came Monday morning while I was reviewing audit schedules at my desk. The restaurant's risk manager introduced herself and referenced the incident report filed the night of my engagement dinner. Their internal policy required documentation whenever a guest was injured on the premises. Because broken glass had been involved, and I had received medical treatment, the matter had been forwarded to their liability insurance carrier. She asked whether I intended to file a claim. I told her I had not decided. I asked what documentation they had preserved. She explained that security footage from the private dining room and adjacent hallway had been retained in accordance with standard procedure once an injury report was generated. The footage was stored on their internal server, but would be provided to their insurer and, if requested, formally to legal counsel. After we ended the call, I forwarded the message summary to Daniel and to Martin Feld. Martin responded first. He recommended that if I wanted access to the footage, the request should come from an attorney to ensure proper preservation and avoid any question about authenticity later. He offered to coordinate with a litigation colleague if necessary. By mid-afternoon, a formal written request had been sent to the restaurant's management on my behalf. The language was careful, not accusatory. It referenced potential personal injury review and asked that all relevant video be preserved without alteration. Late Tuesday, Martin's office confirmed that the restaurant had agreed to release a copy directly to counsel as their insurer required documentation exchange in anticipation of possible liability exposure. The video file arrived the following day. We watched it in Martin's conference room in Bellevue. The room was narrow with glass walls facing a quiet corridor. A paralegal had set up a laptop connected to a monitor so the footage could be viewed clearly. The timestamp in the corner showed 8:17 p.m. The angle captured the end of the table where I was seated, though there was no audio. Taryn was beside me. I could see myself lifting the glass. Then I watched her hand close around the stem. There was a pause, not long, a fraction of a second. Her wrist rotated outward. The base of the glass struck the edge of the table with force. The bowl shattered toward my face, not down to the floor. My head recoiled. Chairs shifted. We replayed it twice. There was no slipping motion, no attempt to steady. The movement was directed and deliberate. Martin did not offer an opinion immediately. He asked the paralegal to document the file receipt and store a secure copy. He said that from a liability perspective, the footage contradicted a purely accidental drop. If I chose to pursue a claim or report the matter to law enforcement, the recording would be relevant evidence. I left his office with a digital copy secured under attorney custody. That evening, I received an email from the buyer's agent for the Tacoma duplex. It stated that Taryn had assured them closing would proceed without delay and that she had indicated internal issues had been resolved. I had not given that assurance. I forwarded the message to Martin and requested that all communications regarding the property sale go through both trustees in writing as required by the trust. The next morning, Taryn called twice. I let the calls go to voicemail. Her message was brief. She said the video would show it was nothing, and that bringing attorneys into a family situation would complicate things unnecessarily. I did not respond. Instead, I reviewed the escrow timeline. The earnest money remained in the trust account, managed by the licensed escrow company in Tacoma. Closing documents required notarized signatures from both trustees. For the first time since the dinner, the uncertainty narrowed. The injury was no longer just a question in a medical chart. It was a recorded act. I did not sleep much Wednesday night. By Thursday morning, I had watched the footage enough times to remove any lingering doubt about what I had seen. The movement was intentional. The contact point was deliberate. There was no loss of grip. At 9 a.m., before logging into work, I called Martin and told him I wanted to proceed. He connected me with a litigation attorney in his firm who handled personal injury and related criminal referrals. We scheduled a same-day meeting in downtown Seattle. I brought a copy of my medical discharge summary and the email chain from the restaurant confirming preservation of the footage. The original file remained in their custody, but counsel had a secured duplicate. The attorney reviewed the materials methodically. He explained that under Washington law, intentionally causing bodily harm could qualify as assault in the fourth degree if no serious bodily injury occurred. The decision to charge would rest with the city prosecutor, but a police report would be required to initiate that process. He asked whether I understood that filing a report would formally involve law enforcement and potentially become part of the public record. I said yes. By early afternoon, Daniel drove me to the Seattle Police Department precinct serving the waterfront district. The lobby was functional and quiet. I provided identification and explained that I wanted to report an assault that occurred at a restaurant the previous week. An officer took us into a small interview room. He asked for the date, time, location, and names of witnesses. I described the sequence of events as precisely as I could. I stated that video evidence existed, and that my attorney could provide it directly to investigators to maintain evidentiary integrity. The officer typed as I spoke. He asked whether I believed the act was intentional. I answered that based on the footage I had reviewed, I did. He issued a case number and explained that a detective would follow up after reviewing the initial report. He did not promise an arrest. He did not suggest an outcome. He outlined the process in neutral terms. When we left the precinct, the air outside felt unusually clear. An hour later, I received an automated email confirming that a police report had been filed under my name. It included the case number and instructions for submitting supplemental evidence. I forwarded it to Martin. By late afternoon, Taryn texted again. This time the message was shorter. She wrote that she had heard from the restaurant that things were escalating. She asked whether I had contacted the police and reminded me that we had a property closing approaching. I did not respond. Instead, I reviewed the trust calendar. The duplex closing required both trustees to appear before a notary within the escrow company's Tacoma office. If either of us refused to sign the sale, could stall. That evening, I drafted a brief email to the buyer's agent and copied Taryn. I confirmed that all trustee communications regarding the sale must be in writing and that no representations about my signature should be made without my direct authorization. The message was factual. It did not reference the police report. Within minutes, I received a reply from Taryn stating that involving law enforcement over a family misunderstanding would complicate the trust administration and potentially alarm the buyer. For the first time, her concerns centered on the transaction rather than my injury. I closed my laptop and sat at the dining table where Daniel and I had been reviewing seating charts just days earlier. The stitches still tugged when I touched the bandage. The decision to file the report could not be undone. The case number existed. The footage would be requested formally by investigators. Whatever happened next would move beyond private interpretation. The dinner was no longer contained within our family. The following week moved in two directions at once. Detectives contacted Martin's office to arrange formal transfer of the restaurant footage. I was told an investigator would review it and follow up. There were no immediate developments beyond confirmation that the file had been logged into evidence. At the same time, Martin advised that we should address the trust issue proactively, rather than wait for any formal petition from Taryn. He drafted a narrow filing in King County Superior Court seeking clarification that no unilateral action could be taken to suspend a co-trustee without court oversight. The filing did not accuse Taryn of wrongdoing. It requested judicial guidance to preserve the status quo pending any dispute. Within days, our office began compiling supporting documentation. As part of that review, Martin's paralegal requested 6 months of complete bank statements directly from the trust's financial institution to ensure we were working from certified copies rather than online downloads. The certified statements arrived by courier. We met in Martin's conference room again, this time with a calculator and a printed ledger. At first glance, the activity appeared routine. Rent deposits aligned with lease agreements. Property tax payments matched county records. Then Martin paused over 3 advances drawn from the trust's secured line of credit. Each advance was just under the threshold that would automatically trigger dual electronic authorization. The amounts were labeled operating expense transfer. They had been initiated through in-person requests at the bank branch in Tacoma. Under the trust terms, even operating expenses required documentation in the trust file. There were no corresponding invoices attached to the digital record. Martin contacted the bank's trust services department for clarification. Because we were both named co-trustees, the bank confirmed that Taryn had presented identification and signed withdrawal slips in person. The branch had processed the advances based on her authority as trustee. They could not discuss further details without a formal written request, but they verified the dates and amounts. The timing overlapped with a separate development. Through routine public records, Review Martin's paralegal identified a small claims filing against Taryn's boutique fitness studio in Pierce County for unpaid vendor invoices. The case had been filed 2 months earlier. The amount sought closely matched one of the advances drawn from the trust line of credit. We did not speculate. We documented. Martin explained that if trust funds had been used for personal business obligations without proper authorization or supporting documentation, that could constitute a breach of fiduciary duty under Washington law. He recommended preparing a supplemental filing, requesting court oversight of trust transactions pending investigation. By the end of the week, the duplex buyer's agent emailed again, noting that Taryn had proposed moving the closing date forward by 5 days. The agent asked whether both trustees agreed. I replied in writing that no schedule change would be authorized without joint consent. An hour later, I received an email from Taryn directly. She wrote that delays were costing us money and that my recent distractions were interfering with responsible management of the trust. She suggested that if I felt overwhelmed, she could temporarily handle trustee duties. I forwarded the message to Martin without comment. The pressure had shifted. The broken glass was no longer the only issue under review. Financial decisions were now under quiet scrutiny and documentation was accumulating. I still did not control the outcome. The court had not ruled on anything. Law enforcement had not filed charges, but the record was expanding beyond a single evening. And once financial records enter a courtroom, they tend to speak in a language that is difficult to reinterpret. The deposition was scheduled for a Tuesday morning in early June. By then, the stitches had been removed, leaving a thin healing line near my right temple. The duplex closing had been postponed by mutual agreement, pending clarification from the court regarding trustee authority. The criminal investigation remained active but unresolved. We met in a rented conference suite in downtown Seattle. A court reporter set up a stenotype machine at the end of a long table. Taryn arrived with her attorney, a man I had never met. She did not look at me when she took her seat. This deposition was part of the civil matter concerning trustee authority and the supplemental filing Martin had prepared regarding oversight of trust transactions. The purpose was narrow establish facts under oath. After procedural formalities, Taryn was sworn in. Martin's litigation colleague began with background questions about the trust, her role as co-trustee, and the line of credit advances. She confirmed that she had signed withdrawal slips in person at the Tacoma branch. She stated that the funds were used for operating expenses related to property management. When asked for specific invoices or vendor names corresponding to those advances, she said, documentation was in process and would be provided later. The questioning then shifted to the engagement dinner. Her attorney objected to scope initially, but the connection was established through her prior inquiry to Martin about trustee incapacity. Under oath, she acknowledged contacting his office to ask about removal procedures. She described it as a general legal question unrelated to me personally. Martin's colleague then displayed still images extracted from the restaurant footage. The timestamp was visible. The angle of her wrist was visible. She stated that the glass slipped because condensation had made it unstable. She said she had attempted to steady it and misjudged the angle. The footage was played in the room without audio. The movement was clear. She maintained that it was accidental. When asked whether she had communicated with the duplex buyer's agent about accelerating closing while I was recovering from injury, she acknowledged speaking to the agent but characterized it as routine coordination. Her testimony was recorded verbatim. At one point, her attorney requested a short recess. When we reconvened, her answers became more measured. She avoided direct speculation about my medical condition. She stated she had never formally sought to have me declared incapacitated. The deposition concluded just after noon. Outside the building, I stood on the sidewalk while Martin summarized what had occurred. Under oath, Taryn had confirmed the withdrawals, confirmed her inquiry about trustee removal procedures, and denied any intent to harm me. None of that resolved the matter, but her statements were now part of the record. That afternoon, Martin filed a motion requesting temporary appointment of a neutral professional fiduciary to oversee trust transactions, until the court could determine whether a breach of duty had occurred. The criminal case remained separate, handled by the city prosecutor's office. No charges had yet been announced. As I drove home, I understood that testimony under oath carries weight beyond private argument. Words spoken casually at dinner can be reframed. Words transcribed by a court reporter cannot be edited later without consequence. The escalation had shifted from emotion to documentation, and documentation has its own momentum. The email from the city prosecutor's office arrived on a Wednesday afternoon in mid-June. It informed me that after reviewing the police report, medical records, and the restaurant surveillance footage obtained through formal request, the Seattle city attorney had authorized a charge of assault in the 4th degree against Taryn. Because the charge was a misdemeanor, she would not be arrested at home. She would receive a summons to appear in Seattle Municipal Court. The message included a case number and a scheduled arraignment date 3 weeks out. I forwarded the notice to Martin and to the litigation attorney handling the civil trust matter. The criminal case would proceed separately, but the existence of formal charges changed the context of everything else. 2 days later, Taryn was served with the summons. I did not witness it, but I learned about it from the public docket update and from a brief voicemail she left that evening. She did not reference the charge directly. She said only that she hoped I understood how far this had gone. That same week, the judge in King County Superior Court reviewed Martin's motion regarding oversight of the trust. The court did not make a final determination about breach of fiduciary duty. Instead, it issued an interim order appointing a neutral professional fiduciary from a court-approved list to serve alongside us temporarily. The order specified that no further advances from the line of credit could occur without written authorization from the neutral fiduciary. All trust disbursements over a defined amount required joint approval, including the independent appointee. Within days, we were introduced to the appointed fiduciary, ACPA, with experience in estate administration. She requested complete financial records, copies of property leases, and documentation supporting the prior withdrawals. Her communication was formal and evenly paced. For the first time, neither Taryn nor I had unilateral operational space. The duplex buyer's agent reached out again, asking whether the scheduled closing could move forward under the new oversight arrangement. The neutral fiduciary confirmed that the sale could proceed as originally contracted, provided both trustees complied with the court's interim order. In a separate development, the municipal court issued a standard pretrial condition in the criminal case, prohibiting direct contact between Taryn and me, except through counsel. It was not framed as a finding of guilt. It was a procedural safeguard. The condition altered practical realities. Taryn could no longer call me directly about trust matters. All communication had to be documented through attorneys or through the neutral fiduciary. Informal pressure ceased. At work, I disclosed to my managing partner that I was involved in pending legal proceedings related to a family matter. I provided the minimum necessary information. Because my role required fiduciary judgment for clients, transparency was important. The firm's response was measured. As long as my performance remained unaffected, there would be no action. Still, the disclosure made the situation real beyond family and courtrooms. On the criminal side, arraignment was set for early July. No plea had been entered yet. The prosecutor's office advised that discussions might occur prior to that date. On the civil side, the neutral fiduciary began reconciling the trust accounts. She identified the same 3 advances Martin had flagged and requested documentation from Taryn within 10 business days. Each process moved at its own pace, but they were no longer abstract. The assault charge existed on a public docket. The trust now operated under court oversight. Communication was structured and recorded. I did not feel victorious. I felt contained within systems that had begun to function. The escalation had shifted from argument to procedure, and procedure once initiated follows its own timetable. The arraignment took place on a Monday morning in early July. Seattle Municipal Court was more procedural than dramatic. Names were called in sequence. Defendants stood, entered pleas, and received future dates. When Taryn's case number was announced, she stepped forward with her attorney. I sat in the gallery beside Martin's litigation colleague, who was present only as an observer. The city prosecutor outlined the charge of assault in the 4th degree. The court confirmed that Taryn had received the summons and understood the allegation. She entered a plea of not guilty. The judge set pretrial deadlines and maintained the existing no-contact condition. A trial date was tentatively scheduled for late summer subject to possible plea negotiations. There was no spectacle, no raised voices, just entries into a docket. Outside the courtroom, the prosecutor approached briefly and indicated that based on the video evidence and medical documentation, the office would likely extend a plea offer prior to trial. Restitution and probation were mentioned as probable components if resolved without a contested hearing. The criminal matter moved into its next phase. On the civil side, the neutral fiduciary filed her preliminary report with King County Superior Court 2 weeks later. The report itemized the 3 line of credit advances and noted the absence of supporting invoices in the trust file. She attached copies of the bank withdrawal slips signed by Taryn and summarized the pending small claims action against her business. The court scheduled a status conference. At that hearing, the judge did not make a final finding of breach. Instead, he ordered that the questioned advances be reimbursed to the trust within 30 days pending full review. He also extended the neutral fiduciary's appointment through completion of the duplex sale and reconciliation of all outstanding accounts. The directive was specific. Funds had to be returned. Within the deadline, repayment was made. The trust account reflected the restored balance. Meanwhile, plea discussions progressed in the criminal case. In late July, Taryn agreed to resolve the charge. Under the agreement, she entered a plea to misdemeanor assault. The court-imposed probation required restitution for my medical expenses and mandated completion of an anger management program. The no-contact order remained in effect for 3 years. There was no admission beyond the legal elements required for the plea. There was no apology in court, but there was a judgment entered. After the hearing, I stepped outside into the summer heat. The case was not erased from memory, and it did not repair the fracture between us. The duplex closing occurred under supervision of the neutral fiduciary the following month. Both trustees appeared at the escrow office in Tacoma at separate times to sign. The proceeds were distributed according to the trust terms and recorded in the court's oversight file. The criminal conviction appeared on the public docket. The civil matter remained open for final accounting, but the immediate financial risk to the trust had been contained. I did not feel relief. I felt the weight of decisions made and recorded. The systems had responded. Consequences were no longer hypothetical. But the personal cost was still unfolding. The final accounting in the civil case closed in late September. The neutral fiduciary filed her concluding report with King County Superior Court after reconciling every transaction in the Ellison Family Trust. The 3 advances had been repaid in full. The duplex sale proceeds had been distributed according to the trust terms. No additional irregularities were identified. At the final status conference, the judge accepted the report and terminated the temporary oversight. The court did not issue a formal finding of intentional breach beyond the repayment order, but the record reflected the corrective action and the period of supervision. The trust returned to joint administration. 2 weeks later, I executed an amendment to my own estate planning documents. I appointed an independent corporate fiduciary to serve in any future trustee capacity, rather than naming a family member. The decision was not punitive, it was structural. The criminal case remained on probationary status. Taryn's plea had been entered, restitution paid, and proof of enrollment in the required anger management program filed with the court. The no-contact order remained active, limiting communication to legal channels. We did not speak. In October, the duplex officially changed ownership. The escrow company recorded the deed, and the trust account reflected the final balance. I received a confirmation statement from the neutral fiduciary summarizing the transaction and closing her file. Daniel and I were married on a clear Saturday afternoon in early November. The ceremony was small, held at a community hall overlooking Lake Washington. The guest list had been adjusted months earlier to comply with the no-contact condition. There was no confrontation. There was simply absence. My mother attended. She sat quietly in the second row. In the weeks leading up to the wedding, she had begun meeting with a counselor on her own. She did not ask me to reconsider anything. She told me she understood that boundaries now existed where they had not before. At work, the managing partner later thanked me for handling the situation transparently and without disruption to client responsibilities. The matter did not affect my standing at the firm. The scar near my temple faded into a thin line that only showed in certain light. By December, the court docket for the criminal case reflected compliance with all probation terms to date. There were no further hearings scheduled unless a violation occurred. The systems had concluded their work. I did not attempt to restore what had fractured. I did not circulate explanations among extended relatives. I adjusted structures instead. The trust operated under clearer procedures. My own estate plan no longer relied on assumption of goodwill. Communication with Taryn remained routed through formal channels, and in practice, it rarely occurred. The engagement dinner had begun as a celebration and ended in a question about intent. Months later, the answer was no longer abstract. It existed in a conviction record in court filings and in amended documents signed in ink. My life did not become simpler. It became more defined. If you have ever had to redraw boundaries inside your own family, you understand that the change is not loud. It is administrative. It is written down. It is enforced quietly. Sometimes that is enough.